And a fair hearing is the appropriate forum to consider petitioner's challenge to the agency's decision to reduce his benefits, which appeared to me that, of course, not only was the request for a DOA-AH hearing declined, but it was clearly contemplated by the order that such a hearing would be held upon request.
Well, it's true that the agency does recognize that under these circumstances, my client is entitled to a fair hearing presided over by a DCF employee with direct appeal to the DCA with no final order issued by the agency making the decision, which is APD. In fact, when I filed the appeal and the designations, I filed a motion that was agreed to supplement the record with parallel administrative proceedings that are going on, and that motion was declined, and my assumption was because that was really not germane to the appeal of this final order.
Well, why is this order a final order?
Because it has the agency at the highest level, I think a deputy secretary or something like that, saying you are not entitled to a DOA hearing. And frankly, to decline jurisdiction of that final order, review of that final order, really presumes the validity of the merits of that decision. I think the court's
hearing orders of DCF hearing orders under chapter officers under Chapter 409 are final orders, are they not?
Yes, but our argument is this is not a 409 case. This is a 393 case, since it's the decision being made by APD. APD has zero authority.
Isn't further administrative action clearly contemplated by this order?
No, sir.
It is not.
No, sir. It provides an option.
So this is a final order in which the issue of JM's entitlement to any Medicaid waiver benefits are conclusively determined, and he has no further resort.
No, sir. It's not. That's not the case. It is saying he has a right to a fair hearing. Mm-hmm. The subject of this case is whether he needs to go through that exercise or whether he's entitled to what the legislature, in our view, intended. It's basically a motion to dismiss. It's basically equivalent to a complaint that's dismissed.
All right. You spent part of your time. I want to extend your time by an additional 3 minutes so that you can address the issue on the merits. I'm sorry I took up so much of your time.
Thank you, Your Honor. If it was agreed that this is governed by the fair hearing procedure under 409, the availability of that remedy might lend itself to the court exercising its discretion not to consider this appeal. But that really presumes the court's view of the merits of the case, and I suggest that the appellant should be heard on the merits of the case before that kind of decision is made. Your Honors may have seen the 3rd District opinion concerning the same child that was issued late last year. This child, it's an autistic, and it's at 924 Southern 2nd, page 1. I don't believe that site was available at the time I filed the brief. Basically, this child was taken, and it's reflected in the 3rd District opinion. He was taken into the system. DCF filed a dependency proceeding against his parents. The trial judge ordered APD to provide services. APD appealed that, and the 3rd District sustained the appeal, holding it was not up to a juvenile judge to order APD to do anything. Quote, the determination of which persons with disabilities are eligible for the Medicaid waiver program and the criteria for such determination has been statutorily delegated to the APD. The trial judge in this matter has neither the jurisdiction nor the authority to make the determination of whether or not JM meets the crisis criteria. Such decision-making power lies only with the APD. So then I filed the request for a formal hearing under the APA. And what I get back is an order dismissing it, saying to take it up with a hearing officer employed by DCF. The focus of this appeal, I would submit, is the proper construction of Section 120.80, subsection 7 of the Administrative Procedures Act. As best I can determine, there is no appellate authority addressing the scope of that provision in the context of the arguments that are being made here today. That statute was drawn very narrowly by the legislature. The legislature said, we are only excusing the need for administrative law judges on the types of programs being operated by DCF, by HRS at the time, as of 1975, and only by its Division of Family Services. I don't believe any court in Florida has yet addressed the scope of that provision. Going back and looking at the statute, one finds two very interesting points. One is the Medicaid waiver program at issue in this case indisputably did not exist in 1975. We cite the Federal District Court opinion stating that it came online in the early 1980s, and it's virtually conceded by the state that although there was, of course, a Medicaid program, the Medicaid waiver program itself did not exist in 1975. The language of the statute is extremely specific in waiving the need for ALJs only under those circumstances. And as we cite in our papers, the Medicaid waiver program is a very complex program. It's not a tiny, modest...
I guess they're arguing that a Medicaid waiver program is a Medicaid program.
Well, it was enacted under the Medicaid Act. That's true, and that's not a matter of characterization. But the Federal District Court held that the waiver program itself, which was a whole entire new program enacted under the Medicaid Act, did not come into existence until the early 1980s, and Florida did not become part of it until the early 1980s.
The provision in Section 409.285,
yes, sir,
authorizing applications for public assistance, that provision was in effect in 1973 prior to the reorganization of the department in 1975, was it not?
I don't know the answer to that question, Your Honor.
I think you'll find if you check the history of the statute that it was. Now, why isn't an application for restoration of the number of hours of rehabilitation services under the Medicaid waiver provisions, why isn't this an application for public assistance?
Because, well, there are a couple of reasons. First of all, if you look through the Florida statutes, you see a wide variety of references to Medicaid in relation to public assistance. Some are consistent with the government's position, some are not. But I think more directly,
you're not saying this is not an application for public assistance, are you?
Yes, sir, I am.
Why? How can it not be? You say this is not contemplated by the Medicaid Act?
Well, I think the phrase that the statute uses is financial public assistance. And I cite a case from Virginia which addressed that issue.
Well, that was a Virginia statute, and that talked about public assistance monies. I mean, you have to look at the specific statute.
It's true. There's a difference in the adjective. That's right. I think one is financial, one is monies, but I think they're analogous. But going beyond that, I think the more germane answer to your question
Someone has to pay for that, and these, I mean, obviously, public monies are being paid to provide for these types of services.
Section 393.125, Your Honor, specifically addresses administrative review of the denial of developmental disability services.
He is receiving services, only he is receiving services at a lesser level of care than that which he had requested.
But what he's seeking review of is a reduction, which is permissible review under the APA. Section 393.125 is the statute which governs, because APA operates under that statute. APA does not operate under Section 4, Chapter 409.
And you're about to tell us about the provision that explicitly references 120.57. There is a provision in 393.
Yes, that's right. 393.125 states, any developmental services applicant or client or his or her parent, etc., who has any substantial interest determined by the agency has the right to request an administrative hearing pursuant to 120.569 or 120.57. I think Judge Irvin would be entirely correct if when the legislature created APD, it had vested APD with Chapter 409 authority, but it never did that. Its authority is the same authority that the DCF's Division of Retardation had in 1975, Chapter 393.
Or the language you just read, was that enacted after the 120.80 sub 7 exemption?
I believe it was. I think it was.
So just reading those two in pari materia, regardless of the precise scope of the exemption, I assume you would take the position that you're entitled to an administrative hearing under the APA.
Well, that's right. And that's right, Your Honor. And that's just the first part of the argument. The second part is that if you trace back the ancestry of what APD was given authority to do in 2004, you go back to the DCF Division of Developmental Disabilities. And before that, and that's what's relevant to this case, when you look at what the state of the law was in 1975, before the reorganization referenced in 120.87, you see that it was the Division of Retardation that handled the receipt and processing of applications for services for the retarded. The state virtually concedes that the Division of Retardation had responsibility for that at the time. Now, then, like today, different parts of state government are focusing on the same kinds of problems from different perspectives. Back to that.
Does it make any difference that in 1973, as Apelli has referred to in his brief, that all programs concerning medical assistance to the needy were administered by the former Division of Family Services, and he referenced Section 409.266, Florida Statutes 1973. Is that a fair statement? Does that comply with the statutory provision?
I would disagree with the characterization of that, Your Honor, respectfully. I'm aware of that statute. What that gave DCF HRS the authority to do through its Division of Family Services is precisely what the trial judge in the dependency case last year was trying to do for this child. Make sure he got services under, make sure the department exercised its authority to provide services. But that did not create what Chapter 393 did then and what it does now, which is require APD to consider applications for services for the developmental disabled.
Did you get their notice of supplemental authority?
Very recently, Your Honor. And I believe it was something that had been cited in the briefs, if I'm not mistaken.
All right, and I guess it wasn't entirely clear, but I think the language they're concerned with is the division shall redetermine eligibility, at least annually and so forth, for recipients of aid to the disabled. And I think we're supposed to infer that this language includes the developmentally disabled. Now, are you telling us that at the time this statute was in a place that the division was called Division of Retardation?
I would have to check that specific statute. But in footnote 2 in my reply brief, I reference all of the places I could find where there was reference to public assistance in Medicaid. And in chapter, the one that the government cited in their principal brief was from the election code. What I cited in footnote 2 was from section 409.2554 subsection 7, which defines public assistance to mean money assistance paid on the basis of, among other things, Medicaid. And that's why I cited the Virginia case, because I thought if you were going to try and figure out which statute most closely reached this fact issue, that would be the statute. And it seemed to me that since there's no money flowing to Jonathan in his facility, but it's flowing to the facility, the Virginia case was very analogous.
Money is flowing to third-party providers, though.
Yes, but that would have also been true, I would submit, in the Virginia case, analytically. The emphasis in the Virginia case was it was going to the provider. It wasn't going to the
Well, don't you agree
client.
that you have to look at the way the particular statute is phrased?
Yes, but even assuming it's correct that public assistance should be categorically equated with Medicaid, then why would the legislature have enacted the section I referred to in Chapter 393, taking it out of the Chapter 409 appellate mechanism the state is relying on?
Well, now that you're talking about Chapter 393, let's take a look at Section 393.065, dealing with application and eligibility determination. And I'm referring specifically to subsection 3 of the statute, which says that any applicant determined by the agency to be ineligible for developmental services has the right to appeal this decision pursuant to sections 120.569 and 120.57. They're using the term ineligible. Obviously, JM is not ineligible for developmental services. He is eligible for a certain level of services. Does that make any difference?
He's been determined ineligible for 8 hours a day of the 18 hours he wants.
Is this the type of Chapter 120 remedy that Section 393.065 contemplated?
I'm sorry, Your Honor, I don't have that specific section in front of me to look at.
Would you like me to read it to you again?
I confess, I don't really understand.
It says, any applicant determined by the agency, meaning, of course, APD, to be ineligible for developmental services has the right to appeal this decision pursuant to sections 120.569 and 120.57.
Of course, that's what I would contend, that there is a right for that APD review. But one of the things that I haven't been able to express myself on, and I'm sorry, because it's my fault, is we have a situation where we have a Department of State government allowing another Department of State government to make its final orders. How can that be squared with the purposes of APA review? It turns the AP on its head. If the purpose of APA review is to give the agency, to require them to take a second look, how is that taking place here?
Well, does it make any difference that this has been a long-standing determination or interpretation of the statute at least by DCF, that an applicant for this type of relief is entitled only to a fair hearing rather than a 12057 hearing?
That there's nothing to that effect, to my knowledge, in the record. There's no train of administrative decisions.
Well, I think you're right about that. However, you did cite this Russell opinion, and in fact, the hearing there was conducted.
Yes, and this, I'm sorry, may I answer the question? That's right. This court, in a series of statements contained in that opinion, I think at least was suggesting some question as to whether this is free from doubt as to whether DCF ought to be deciding these cases. This court didn't say that, but if you read that case, I came away with that impression.
So haven't some of these cases ended up in DOA?
Yes, sometimes. This is not in the record, so I feel very uncomfortable relating this. I think sometimes ALJs have refused to send things away, and I think sometimes the agency, at least under DCF, might exercise discretion to allow an ALJ to hear it, and they certainly do have the discretion. Even if they're correct, they have the discretion to do it. But what I'm suggesting is that if we file a facially sufficient 120 petition, they must refer it to DOA if that's what's requested in a Medicaid waiver program.
Okay, your time has expired. I'll be happy to extend your time by an additional 2 minutes following argument by appellee.
Thank you, Your Honor.
If you like, I'll be glad to extend your time by an additional 2 minutes.
We'll see what I need. I tentatively accept, Your Honor.
Would you mind addressing the jurisdictional question that I asked Mr. Mitchell first, please?
It would appear that the order is a final order of APD. At the same time, Your Honor is correct in that certainly a subsequent decision by the fair hearing officer of DCF could obviate the necessity for review at all. So to that extent, it's not. The agency did take jurisdiction. They requested the appointment, the reference of the case to DOA for a hearing by an administrative law judge, and the clerk of the Agency for Persons with Disabilities did issue a final order saying that's not appropriate. The fair hearing process is appropriate. And indeed, the fair hearing process has been one that the petitioners has been pursuing.
So the proceedings at APD have concluded, and you contend properly so.
Yes, that would be correct, Your Honor.
So that's the distinction then. In the Ford case, the order was entered by, I believe, a DCF hearing officer.
Yes, Your Honor.
Officer.
Yes, Your Honor, that's correct.
Well,
it would. Clearly, this issue is going to come before this court. Anyway, it may be premature. It may be we should wait until there's a decision by the DCF hearing officer. Our position is that we did issue a final order.
well, is it your position that APD now has jurisdiction at least to consider initially these applications?
Yes, initially APD does have jurisdiction to consider the application.
Then if it has jurisdiction to consider an application, why indeed then under the clear language of the statute, that is under 393.065 and 393.125, why should not the matter have been referred to a DOA hearing officer?
Because the Medicaid program existed prior to 1975. It was administered by the Division of Family Services at the time. Therefore, the language of 120.87.
In what respect were benefits given to retarded persons at that time administered by the Division of Family Services?
They were administered in a number of ways. Actually, all the Medicaid programs were. But
at that time, correct me if I'm mistaken, and this is certainly day horse the record, but at that time wasn't the Sunland institutions were the basic means of providing services to mentally retarded persons?
My recollection is it was the primary means, yes, Your Honor.
And what is it also not the case that the Division of Retardation administered those institutions?
That's true, Your Honor, at least in terms of it managed those institutions. But a good deal of the funding which went to them was funding through the Medicaid program, which was administered by the Division of Family Services.
Well, now let's talk about that. There was no central financial entity controller within HRS?
It was the Division of Family Services that did that in terms of all public assistance. Essentially, Your Honor, the Division of Family Services under Chapter 409 administered care of children. It administered institutional care for children, determination of eligibility for financial assistance, determination of amount of financial assistance, old age assistance, aid to the blind, aid to the permanently and totally disabled, aid to families with dependent children, medical assistance for the needy. Virtually all public assistance programs were administered by the Division of Family Assistance prior to 1975, Your Honor.
All right, but there was a difference between AFDC and the Sunland institutions, wasn't there?
Of course, Your Honor, just as there's a difference between food stamps and Medicaid. But the fact is that the funding for each of those programs and the determination of the appropriate level of funding was determined by the Division of Family Services. And
Or let's say some family wanted a mentally retarded member of the family to be housed at Sunland. What would be the role that the Division of Family Services would have played?
my understanding, based upon the statutes, is they would have determined first, the application would have made incidentally not to the Division of Retardation, but to the Department of Health and Rehabilitative Services at the time, but it then would have been evaluated by the Division of Retardation, who would have determined whether the person was in fact retarded and what kind of services the person was eligible for and would be appropriate for that person. However, subsequent to that, there would have been a second level of review of those services and of the costs involved, since those services would have been paid for through public assistance money, and that was the basis of my notice of supplemental authority. The second tier review was done by the Division of Family Services, which, pursuant to statutes 409.185 and 195, which provide that the division shall redetermine eligibility at least annually for the recipients of old age assistance, and including aid to the disabled, and further 409.195.
But so at that time, and I understand that thereafter, mentally retarded persons came to be designated developmentally disabled. However, at the time of this statute, that was not the case. Is that correct?
I don't know when the term developmental disability came into popular use, Your Honor. And of course, we know that it includes people other than retarded persons.
Well, my question, of course, is whether it actually includes retarded persons.
It, according to the definitions being used by the Agency for Persons with Disabilities, it does include retarded persons, Your Honor.
No, but we're talking about a statute that was on the books back in the 70s, before the APD came into existence.
I really don't know how to respond in terms of what the definition of the term was prior to 1975.
So it may be that the statute you furnished us doesn't answer the question.
That's possible, Your Honor, but it certainly would appear to, in that virtually all public assistance, and we know that funds were paid to Sunland to operate their programs through Medicaid and other public assistance entities, and we know that those public assistance entities, at least had to have been administered by the Division of Family Services, because virtually all public assistance.
Well, why is this analysis necessary at all? I'm talking about the pre-1975 reorganization analysis, the exemption that appears in 120.80, paren 7, i.e. the exemption from Chapter 120 processes. The reason I say that is that statute was initially enacted in 1976. It was placed under 12057. Of course, it was transferred to where it is now. The reason I say that is that the amendments, there was an amendment made to the more specific statute, the application statute, Section 393.065 in 1988, which clearly accorded 12057 remedies to applicants. Can't we say that the exemption provisions in 120 point 80(7) have since been superseded by later statutory provisions, which
No, Your
now
Honor.
accord a hearing to a substantially affected party?
Not insofar as it would be
Talking about a
interpreted to require an
120-57.
ALJ hearing. Your
Pardon?
Honor. Not insofar as it would be required, it could be interpreted to require a hearing before an ALJ.
Why?
And
Why not?
There's two reasons for that. One, Your Honor pointed out earlier, in that the statute refers to eligibility, not reduction, and incidentally, reduction was specifically a matter which was within the jurisdiction of the Division of Family Services prior to 1975, pursuant to 409.195.
But now the legislature, since that time, though, the legislature has accorded a remedy which was not available. It first accorded that remedy in 1988 under 393.065, and again in 1989 to under 393.125, hearing rights, providing that a person whose substantial interests are affected has a right to request an administrative hearing pursuant to 125.69 and 125.7.
It seems highly unlikely that the legislature could have intended those statutes to supersede the requirements in Section 409.205.
Doesn't the more specific statute prevail over the more general statute? In other words, this statute is, that is 393.125, for example, is specifically geared or referenced to any developmental services applicant. That language doesn't appear in 120.80(7).
That's true, although my recollection is that that statute is also specifically limited to eligibility, not reduction. Also, it would be in direct violation, which certainly the intent of the legislature is the pole star of statutory interpretation, of 409.285, which states, if an application for public assistance is not acted upon within a reasonable time after the filing of the application, or is denied in whole or in part, or if an assistance payment is modified or canceled, the applicant or recipient may appeal the decision to the Department of Children and Family Services in the manner and form prescribed by the department.
What about the opposing counsel's point that it's highly unusual, and in fact, to my limited knowledge, unprecedented, for anybody to suggest that the legislature has told one agency to whom a request for hearing has been addressed that they should refer it to some other agency other than, of course, the Division of Administrative Hearings?
Well, that's a problem that doesn't really exist in this case, Your Honor, because pursuant to Section 120.197, the Agency for Persons with Disabilities is housed within the Department of Children and Family Services for administrative purposes. So,
now that particular arrangement is not uncommon in state government. Is that correct?
I don't know, but certainly I would suspect that it's not uncommon.
Well, I believe the Division of Administrative Hearings itself is housed within the Department of Management Services. And so we're not suggesting, are we, that DOA could refer to DMS hearing requests addressed to DOA?
If the legislature had permitted it, I would suspect that then it would be permissible. But
it's exactly the same language that or very close. The language is very close to what you're talking about here. That APD is organized separately from DCF, right?
Absolutely, Your Honor.
In fact, evidently, the legislature thought we want a little more accountability here. We want the head of APD to be appointed by and answerable to the governor. We want APD to be formulating the policy in this area, including, presumably, by participating in administrative hearings and addressing recommended orders in due course. And now it seems like there's the administrative response is to collapse that back into DCF in defiance of the legislative directive.
Your Honor, the language would seem to be inconsistent with saying utilization by APD of DCF for an administrative purpose is in defiance of legislative intent, where the legislature stated that it would be housed there for administrative purposes.
Well,
it would seem to be entirely consistent with legislative intent, and certainly that would be our position.
I can't follow that argument, because the application language of 393.065 doesn't say anything about applying to DCF. The language is very clear that an application for such services shall be made to the agency, and the agency is defined as APD.
That's absolutely correct, Your Honor. And APD makes an initial determination, and APD makes a subsequent determination, the second-tier determination that we're talking about here, where the services that were recommended the first time with regard to residential habilitation were decreased from 18 to 10. Incidentally, the second-tier review, same kind of second-tier review that was done by the Division of Family Services prior to 1975.
Where is that second-tier review stated and provided under Chapter 393?
I don't recall, Your Honor, but we know that that's what's happened. That's the allegations of the petitioner, and we know that what happens as a matter of procedure is a waiver support coordinator recommends a certain level of...
It seems to me your best argument is that simply that this type of service that's requested is public assistance, and it properly falls within the ambit of Chapter 409 rather than 393. However, you do concede that APD has jurisdiction. If APD has a jurisdiction to consider an application for reduction of services, it seems to me that the clear language of the more specific statute would prevail over the more general statute, and that APD would be required to refer the matter to a DOA officer for a hearing.
Well, the language of 120.87 appears to apply to the administration of programs no matter where they wind up going subsequent to 1975. We know that the public assistance program that was Medicaid, portions of it subsequently and new programs went to other agencies, and some of them, including the Home and Community-Based Services waiver, went to APD. But the fact that it went to APD and APD can make a determination does not change the fact that it's part of the Medicaid program that was administered by the Division of Family Services prior to 1975. Therefore, 120.87 clearly does apply. It is entirely consistent with 409.285, both subsequent to 1975, which requires a hearing before DCF hearing officers, and prior to 1975, where the same statute existed, but required a hearing before Division of Family Services hearing officers. Thus, it's clear that the administration of the program that is specifically concerned herein was administered by the Division of Family Services prior to 1975, that 120.87 would apply and does apply, and indeed that it would be a violation of federal law if 120 were to be strictly applied.
Do you mean to say that the states are not empowered to perhaps impose more liberal remedies than those provided under the Federal Medicaid Act?
Your Honor is using the term more liberal, but that the Code of Federal Regulations requires what it requires.
They required the very minimum. I think the minimum is a fair hearing, but
But
it does not, it does, clearly doesn't.
It's more than just a minimum, though. It's specific, it specifies where the hearing is supposed to take place, Your Honor. It states a hearing before the agency, which isn't a problem here where the agency is housed within DCF, or an evidentiary hearing at the local level with a right of appeal to the state agency hearing. Now, there isn't any dispute whatsoever that the 120 DOA...
Why wouldn't a DOA hearing meet those requirements?
It is because it does not provide a hearing before the agency. We know that. It would be another agency. And it would not be providing an evidentiary hearing at the local level.
So there's no reason why the agency head, if concerned about that problem, could not conduct these hearings.
My understanding is that this case was about whether an administrative law judge was required.
Well, it's whether 120.571 should be allowed to operate the way the statute plainly provides.
The agency has the option of conducting the hearing itself.
And we contend that under the exception, under 120.80, it also has the option of referring the matter to a DCF hearing officer, which meets all the requirements of CFR. Now, what would be proposed if an agency head had to do each of these hearings themselves? Of course, that would be practically unworkable, because they spend all their time doing such hearings.
No, we're outside the record again.
I'm sorry. Yes, you're correct, Your Honor.
Thank you. Your time has expired.
Thank you very much. We would contend that the exception applies and would ask the court to so hold.
Thank you for the time, Your Honors.
How about that? Did we have a supremacy clause problem here?
Absolutely not. In the reply brief, we went through each of the criteria that the state says are required by basically the state doesn't want to lose funding. And so they say we have to comply with these CFRs. So we went through, counsel cites the CFRs in his answer brief. We went through the same CFR provisions he mentioned and went through each and every of the requirements. In each and every one, counsel's in favor of APA review. A very similar issue came up in Indiana, and we cited the case there, which upheld the right to have a two-tier review and rejected arguments that it shouldn't occur. What would happen if this were being treated like any other APA case is this would be referred for recommended order to a DOA ALJ. It would go to the agency head with any exceptions people wanted to make. They would make the final order. That way, there's the local hearing in front of the agency. There's a recommended order in front of DOA. Then it goes for final order by the agency head. And it has the virtues of due process that federal law requires that APA wants to withhold.
I think actually the way the statute is written, either the agency head or an ALJ can conduct the hearing, but once a recommended order is entered by an ALJ, it need not go back to the agency head. It can be delegated. The agency head can delegate to somebody.
Yes, that's right. One of the questions that came up before and the council was responding to was, I think there was a statement made that applications for services were made to the Division of Family Services and not to the Division of Retardation. In 1975, Chapter 393.021 is entitled Application for Services, and it goes through how the Division of Retardation is to review that.
Go ahead.
Thank you, Your Honor.
He claimed there's some second-tier review. I don't know with what record or other basis. But.
Well, then the argument was made that all financial decisions were made by the Division of Family Services. And it's interesting. If you look at the 1975 version of 409.026, it says in subsection 1, pursuant to regulations promulgated by the department, the division, that is the Division of Family Services, shall determine the amount of money or other things of value that each applicant or recipient of assistance or benefits under this chapter is entitled to receive. But that's Chapter 409, not Chapter 393. And it's a little more interesting because when you turn over to subsection 6, it speaks more generally about the department being authorized to receive all kinds of federal reimbursement. So if the legislature had intended for the Division of Family Services to accept money from the federal government, then why aren't they referenced in that section? The argument is then, I beg your indulgence, tell me when to stop, and I'll stop. The argument is made that
As soon as you finish this sentence, you can stop.
very careful.
You walked into that one.
Judge Benton, you wrote in the IB case that the Administrative Procedures Act does confer the right to, quote, a hearing wherein they have an opportunity to change the agency's mind. The agency is no longer present in this case to even make that appeal. We would ask that it be reversed with instructions to refer the petition to DOA for the assignment of an ALJ. Thank you.
Thank you. We stand adjourned.